Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody, and Happy New Year. I'm going to give you a few minutes to join as we're starting our first Fridays of 2026. Just want to say thank you to everybody for being here this morning. Looks like right now we have about 28 questions, which is amazing. So welcome, everybody. Just some quick introductory remarks. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. I'd like to welcome you this morning to our firm's first live virtual First Friday event for the month of January 2026. I hope that you and your families had a wonderful holiday season and are gearing up for a great 2026. Just some background information on our firm. Well, first, I've been practicing law in this area for over 29 years, and our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I've also been very actively involved with my board of directors where I live for the past 14 years. And I'm on two boards, actually, the master and the sub. And that has been enlightening. And I've learned a lot from that role as well. Here's how First Fridays is going to work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer all the questions between now and about 10 a.m. or however long it takes for us to get through all of the questions. Just a quick friendly reminder, due to the large volume of questions that we receive, this free opportunity is limited to one question per association. So if you plan on submitting a question live during this session, please include the name of your HOA or condo and your current role when you submit your question. And just some starting points for today. I want to mention just a couple things. So first, Happy New Year. If your association isn't doing it yet, it would be a great idea for you to start working on your goals for your association for 2026. Some suggestions on that would be try to just come up with like 5 goals for your association this year, maybe 2 larger ones and then 3 ones that are, can be easily obtainable in the first quarter or second quarter. And then the larger ones are going to be more long-term planning goals for your association. Just so you know, our firm has been doing a lot of boot camps for associations on Zoom, and we help with the goal setting. We help with going over what your responsibilities are as board members, and we help solve any internal problems or questions that you may have as a board. So keep that in your back pocket as something that you may want to consider doing in the first quarter of 2026. And the best way to schedule that is just to reach out to me directly at our firm at info@mulcahylawfirm.com. Okay, quick update on the legislature, Arizona legislature. It's 2026, so they're going to be back in session, and we are already closely monitoring the bills that pertain to HOAs and condominiums that have been introduced so far this year. There are 2 kind of interesting bills that we've seen this year. The first one talks about lighted address signs, and it's identical to the one that was introduced last year that failed ultimately on a third read vote in the House, but it did pass the Senate. And so kind of interesting that it pertains to both condominiums and to planned communities. And it provides that associations cannot prohibit installation of lighted home devices that provide a lighted display of the house number. So that's the first bill. I mean, I'm of course not opposed to that at all. I think that's a good idea. The other bill that we noticed that has been introduced and is going to be moving forward, I'm sure, is talking about actions by written consent in condominiums. And it specifically says that in a condominium that this is not allowable. So the Nonprofit Corporation Act section that pertains to this does not allowable. So kind of interesting. I mean, we've been advising our clients that all along, that taking actions by written consent absent an emergency circumstance shouldn't be done based upon the plain language of the Arizona Open Meeting Law. So interesting to see that finally coming to fruition for condominiums, and actually also applies to planned communities as well. Okay, so let's hop right on to our questions. I'm going to do a quick question check how many questions we have so far this morning. We're still at 28. So we'll just start working through all the questions right now. Okay, this first question is from an owner. It's 33-1804, allows for consideration or discussion of a member's appeal. The board is voting on these items in closed session instead of moving the decision and vote to open. Is voting in a closed session allowable under this statute? So this particular owner has a question regarding executive session meetings, and basically, I think the section that they're referring to is that the board may go into executive session to consider or discuss a member's appeal. And unless the owner wants to have the discussion to be done in the open session, if that happens, the owner requests it, then it gets moved to the open session. So I think your question is, you're focusing on the fact that that plain language of the statute says consideration or discussion is the only topic, is the only topic that's listed in the statute, that you can talk about for the member's appeal. It doesn't say vote. So it just says you can go into executive session for consideration or discussion of an appeal. It doesn't say consideration, discussion, or vote. Honestly, I think consideration is pretty broadly defined, and I do think that the board can vote on this during the executive session. Now, if the owner wants the entire situation to be moved to the open session, all they need to do is ask, because the statute specifically says that if the owner wants this in the open session, it goes to the open session. I do think consideration will cover being able to discuss it, vote on it in the closed session if the board chooses to do so and the homeowner doesn't request it in the open session. Okay, question number 2 from an owner. We are a gated private street association. If we place signs on our streets that wrong-way parking is prohibited, would we then be able to call the Mesa Police Department for violations and ticketing? Is there a way to accomplish police enforcement of parking? So great question. Kind of the first baseline question that I would have is, are your streets dedicated to the city or owned by the city? And if they are, then the City of Mesa Police Department will be handling violations and ticketing. What I would suggest is that you contact the Mesa Police Department and find out what the ordinances are pertaining to on-street parking, because that's going to dictate. Just because you put a sign up doesn't mean that the Mesa Police Department is going to enforce it on a public street. So I would contact the police department, find out what their ordinances are on parking, read up on those, make sure you notify your owners about those ordinances and that there will be enforcement. And then when you see violations, find out from the police department what's the best way to report it. Okay, question number 3 from a community manager. As was acceptable during COVID, is it still acceptable for HOAs to conduct their annual meetings completely by mail? If a member questions or concerns are requested by mail and addressed individually, does the HOA have to meet in person if not required by the CC&Rs or the bylaws? So great question from a manager. The COVID-19 pandemic was kind of a unique time in our history of associations, but I wouldn't say that I ever told associations it was acceptable to conduct an annual meeting completely by mail. Our firm never advised that. We suggested that associations convert quickly and conduct their meetings by Zoom or by Teams or whatever platform they thought it would be easiest for owners to participate. It's our opinion that it's not acceptable to have an annual meeting by mail ever. And we still see a lot of associations having annual meetings by Zoom because there's a lot of benefits to it. It's easier for people that live off-site. It's easier for elderly, handicapped people to attend the meetings, and it's easier to actually keep control of the meeting so that if somebody's getting disruptive, we can mute them as the administrator for the annual meeting. So short answer would be it's not acceptable. And what associations are doing now is they are either having meetings in person, annual meetings in person, which honestly is becoming more rare. And most of the associations are having the annual meetings by Zoom. Remember, if you are having an annual meeting in person or by Zoom, owners should be allowed to vote in person at the meeting. And if that's in person, that means if they're in person at the meeting, they hand the ballot in. Or if they're attending via Zoom, that there has to be a way for them to hand in the ballot once the Zoom call starts. Typically, we have them take a picture of it on their phone and email it to a designated person. So I think that answers your question. Question number 4 from board. We recently received notice of a foreclosure on one of our lots. The notice identifies the lender as the owner due to foreclosure action. Does this affect the lot owner's rights in the HOA as for voting and other privileges? So this is a good question. You may want to reach out to me individually to discuss this because there are pretty serious implications if there's a new owner on the property and you want to make sure that they start paying assessments immediately. But here's kind of how it works. If you recently received a notice of foreclosure, I'm guessing it was probably like a trustee sale notice, or maybe it was a trustee's deed. There's a difference between those documents. So if it's a notice of trustee sale, that means that they're going to be conducting a sale of the property for the owner not paying their mortgage or their deed of trust. And it's usually a date certain in the future, like 2 or 3 months forward. If you received like a trustee's deed, that means that a third party has purchased the property at the trustee sale, and now that person is the new owner. It sounds like you're saying the notice identifies the lender as the owner due to the foreclosure action. So what may have happened is that the lender may have taken the property back at the trustee sale. And what happens there is at the trustee sale, the lender, puts the property up for sale. And if no one buys it, then it reverts back to them and they become the owner. So that could very well be what happens here. Once the date that the deed is recorded, showing that the lender is the owner, then the lender from that date forward has to pay assessments. So just keep that in mind. We'll create a new ledger for the lender from the date that they took the property over, and that will be the date that the deed was recorded. Does this affect the lot owner's rights in the HOA for voting? Well, if it's a trustee sale pending, no. If a trustee deed has been recorded and they are no longer the owner and there's a third party or a bank that's now the owner, that owner has no rights anymore and they're no longer an owner. Okay, question number 5. How can the board have a goal-setting meeting or workshop and not violate Arizona open meeting law? So great question. The Arizona revised statutes that pertain to condos and HOAs are pretty clear that anytime a quorum of the board is meeting to discuss association business, whether it's a meeting that they're going to vote on things or whether it's a meeting that they're just planning or doing goal setting or workshop, it has to be an open meeting. And members need to be notified at the meeting 48 hours in advance. And so the way to have that meeting without violating open meeting law is have less than a quorum there. That is the only way that you can do that and not violate Arizona law. Okay, question number 6 from a board. What legal or liability risks, if any, would the association face by removing the 2 AEDs currently maintained by Cintas while retaining a single HOA-owned AED, including any statutory or common law requirements regarding the number of AEDs, recommended best practices for inspection, testing, maintenance, documentation, and training, and the extent to which maintenance records or the presence of or absence of user training could affect the association's potential liability exposure? Okay, so this is a good question from the board. So AEDs are becoming more common in pool areas and common areas. And it sounds like Cintas, who is like your security company, has been currently maintaining the AED for your association. Personally, I guess my opinion would be, I think I would continue with having them maintain it because there is some liability and risk. If the board is maintaining it individually, the risk is that if somebody comes on the property and needs as a health event and we need to use the AED to resuscitate them and it doesn't work, there could be liability for the association. So I think it's better to shift that liability to Cintas. If you absolutely don't want them to do it anymore and you want to handle that going forward, you can negotiate and contract directly with an AED company and then just follow whatever their recommended procedures are for maintaining it, the training that's required, etc. Just so you know, I have been through the training myself, just in a different capacity, not related to HOAs. And it's actually really easy to use. It's when you open it up, it tells you exactly what to do. And it factors in that the person who's using it on another person is a highly stressful situation. So they're typically, I think I did the training in like 10 minutes in conjunction with CPR, which took longer. So the training isn't that big of a deal, but making sure the machine works, that's important. Okay, question number 7 from a board. Our HOA president requested that directors submit items for a draft agenda, though no draft has been prepared or circulated. After I submitted 3 items, the president asked directors to vote by email yes or no on whether my items should be included, with a majority vote determining inclusion before the meeting. I believe this procedure is improper, as my understanding is that the relevant director requested items should be included on the agenda, and any discussion or approval of the agenda occurs at the start of the meeting, not through a pre-meeting email vote. Okay, so great question. I mean, I guess from my perspective, I don't think that there's any right or wrong way to handle the agenda. So state law doesn't specifically say, oh, you have to do it this way or you have to do it that way. Basically, I think it's nice that your president requested directors to submit items if they had any for the draft agenda. And then if there was any controversy, letting the directors decide by majority vote whether or not it should be included. And it sounds like the item was included, so everybody should be happy, right? If it wasn't included, what you could do as a director, if it's your item, is just during the homeowner forum at the beginning of the meeting, get up as a homeowner and talk about the item that you wanted to have included that the board voted against you having included. So short answer is you think this procedure is improper. There is no hard and fast rule on this. So I think I've given you some suggestions. We really can't decide on what's going to be on the agenda at the start of the meeting because Arizona law requires us to provide an agenda 48 hours in advance of the meeting. So the procedure that you're recommending really wouldn't work under Arizona law. Now, the exception to that would be if there's an emergency that comes up and we need to talk about a topic quickly at a meeting and we didn't have 48 hours notice time to notice it, then of course you can always add it under new business or old business or something like that. Okay, next question, number 8 from a board member. Can minutes of a closed board executive session be approved at an open board meeting if they are not discussed or amended, but simply presented for approval? Do they have to be approved only at another executive session? That's a really good question. As if the board's okay with it, I'm okay with it. So executive session meeting minutes typically are approved at the next executive session. That's the kind of the protocol that we typically follow. But sometimes you don't have executive sessions. If you're a board and you don't have a lot of executive sessions, that's probably a good thing. You probably don't have a lot of problems. And so if you want to approve them at an open board meeting, you certainly can, as long as there's not going to be discussion or any amendments to them, unless the board's okay with talking about them at the open session. You don't have to go into executive session under the law. It's a right. It's not an obligation. So really how you handle this is up to the board. So short answer is normal practice and procedure is you approve executive session meeting minutes at the next executive session. But I'm not opposed to, and I don't think there's anything under Arizona law that would prohibit you from reviewing and voting to approve executive sessions at an open board meeting. Okay, next question, number 9. Our community has had issues with pigeons roosting under the eaves of condo roofs. The HOA is responsible for roof maintenance, but not pests unless common areas. The board in the past has instructed owners to contact a pest control company and remedy the pigeon issue themselves. Now we have a new manager that states per management attorney that the HOA is responsible for the pigeons. CC&Rs state roof maintenance and its components. How to handle this situation? Is it maintenance or pest control? Okay, so we're responsible for roof maintenance, but you're not responsible for pest control in your community association. The board in the past has instructed owners to contact a pest control company and remedy the pigeon issues themselves. Now it's the new manager says that the HOA is responsible for the pigeons. I mean, I think, honestly, I agree with the board on this. I think that this is a homeowner issue. Now, I haven't really noticed that. Okay, so maintenance would be like if it starts rotting or if it is leaking, that type of thing. But just because you have like a hornet's nest or pigeons that are nesting in this area doesn't necessarily make it the association's responsibility. So I would disagree with your new management company. And I would instruct the owners to take action on this. So I think it's definitely pest control and it's not maintenance. So I disagree with your new management company. Okay, question number 10 from a community member. Can a board make policy changes by proclamation without changing the CCNR's rules or bylaws? That's a really good question. It depends on what they're changing. I mean, if they're changing, hey, we're going to have our board meeting the third Tuesday of the month at 11 a.m., and it doesn't conflict with anything in your CCNR's rules or bylaws, then yes, that's fine. The board can just make that decision at an open board meeting. What the board cannot do is make policy changes by proclamation that conflict with your CCNR's rules or bylaws, or maybe even that extend the meaning in certain circumstances. So, like, let's say that your CCNRs say that owners can rent, and that's a right of an owner. And then the board makes a proclamation that says, oh, well, no, the board, you can rent, but the board will only allow you to rent for a 30-day minimum period. I mean, that conflicts with what your CCNRs say because your CCNRs give you an absolute right to rent. So it's kind of a case-by-case basis, but the rule of thumb that I would go by is that policy changes by proclamation should not conflict with the CCNR's rules or bylaws. And you have to be really careful if you're further interpreting the CCNRs in a way that limits an owner's rights. Okay, question number 11 from an owner. How many years does an HOA have to keep their budget comparison sheets, as well as how many years for plumbing records, especially if there is an ongoing issue that has still not been addressed? So we actually have a great cheat sheet on this topic. You can locate it on our website at mulcahylawfirm.com. And it talks about records retention. And just go to cheat sheets, type in, keyword records, and it will pop right up. So short answer on this, and that gives you a full summary of everything that you potentially have as records and how long you need to keep it. So the question is, how long do we keep our budget comparison sheets? So like your year-to-date budget sheets, as well as how many years for plumbing records? I would keep the budget comparison sheet for at least 7 years and probably plumbing records. I mean, I don't know if this is just like bills or if it's like an incident that occurred, but probably 7 years for that as well. If there's an ongoing issue that hasn't been addressed, then you need to factor that in, and maybe you're keeping it much longer than 6 years or 7 years. I picked 7 because it's a 6-year breach of contract for statute of limitations. So we can only be sued within 6 years of whatever the breach was. So I did an extra year just for good measure. So I think that's probably about how long you have to keep it. But remember, most associations now are putting everything on the cloud. So if you do that, you probably can keep it significantly longer. Okay, next question is from a community manager. Can a board member run an unofficial Facebook page, run community contests, post neighborhood activities and announcements, and decide who she chooses to be in the group? I'm laughing because unfortunately, I've seen this problem before. Okay, so really, board members should not be running an unofficial Facebook page for an association. The association should be running an official Facebook page for the association if there's a need for it. So I really don't like the idea of a board member putting themselves out there, and it's liability for that person as well, and running a Facebook that's unofficially official for your association, and then intentionally leaving people out, not letting them be a part of the group, etc. That is, in my opinion, borderline breach fiduciary responsibilities to the corporation and could be subjecting that individual board member to liability. So a couple thoughts. I think the association, if there's a need for this, the association may want to consider having a Facebook page or an Instagram page to make these type of announcements. And the board should notify this board member, please stop doing this. And I have had this situation before where we asked the board member to please stop running this satellite Facebook page that talks about the association, etc. Okay, question number 13 from a board member. We are an HOA for 12 single-family homes. We have had 3 board members, but 1 recently moved away. Can we wait till our March 2026 annual meeting to elect a replacement? What if no one runs to fill the spot? Okay, so you're a small association and you have 3 board members. You're down to 2 now because somebody moved. Can we wait until our March 2026 annual meeting to elect a replacement? So short answer would be yes. I mean, it's already January and 2 out of 3 is a quorum. If 3 is the maximum number of board members you have total. So I think you can just kind of, Band-Aid it to March. What if no one runs for the spot? Well, if that happens, first of all, the next few months, you need to really amp up your communication to the other owners. Sounds like there's 9 or 10 other owners that potentially are people you could recruit, and just talk about the need to have another board member. If you can't get anyone to serve on the board, 2 is enough. You have a quorum with 2, but it would be so much better to have 3. In some cases, our firm will write a letter to the owners and talk about what the implications are of not having enough people to run on the board, and that this could be creeping closer to having a conservator be appointed to run the affairs of your association. That's kind of a drastic letter to send because it's not like you don't have anybody on the board. You do still have a quorum, but you may want to consider doing something like that if the 2 existing board members get sick of being on the board and now there's nobody to run the board. So hopefully with good communication, you'll be able to round up people to serve on the board. Typically, we send out mailers on it, emails asking people to volunteer. If they don't volunteer, then really the next step would be for us to pick up the phone and start calling owners. And if that doesn't work, then we can maybe flip to have my firm send a letter just explaining that, hey, if we can't find people to serve on the board, this could be heading towards a receivership, having to run the association. And that is very expensive for the association. Okay, next question, number 14. My 12/18/2025 monthly statement required by ARS 33-1807 item M shows a higher monthly assessment due on 1/1/26 than 2025 auto payment amount with no other notation or context. Our CC&Rs state that the board of directors shall fix the amount of the annual assessment against each lot at least 30 days in advance of each annual assessment period. Written notice of the annual assessment shall be sent to every owner subject thereto. Does the monthly statement constitute written notice, and should the discussion action have been included in a meeting agenda or the minutes for owner input? So great question. It sounds like you had an increase in your assessment rate. And if I had to guess, your board, I'm sure, voted on this in an open board meeting. So there probably are minutes to reflect that. And so it's saying that the amount has to be fixed 30 days in advance of each annual assessment period. So if they talked about this 30 days before January 1, they've complied with it. They talked about it at a board meeting. And I do think that the monthly statement required by ARS 33-1807M does qualify as written notice. In situations where you raise the assessment, it's also really smart to put out other information to your community so that people pay the right amount in January when the increase occurs. But I don't see anything wrong with how this was handled. And it should have been discussed in the open board meeting minutes, and minutes should have been taken showing that. Okay, question number 15. Our CC&Rs prohibit rentals except for owners who were grandfathered prior to the restriction in the CC&Rs, and state that this right terminates upon transfer of title. If a grandfathered owner held title in a revocable trust of debt, which then became irrevocable with a new trustee and a tax number, does the change in trust status or trustee constitute a transfer of title under the CC&Rs? The property remains titled in the trust and has not been sold. We have historically treated such properties as retaining grandfather status so long as the title remains in the trust, but we have seen differing legal opinions and seek clarification on the controlling law. Thank you for all that you do for our communities. Okay, great question. So I guess it really depends on what the language of the rental provision grandfathering said, but usually if the property didn't change hands, meaning that there was no change in title and it's still in the trust's name, that grandfathering would continue with that particular property as long as it's still in the name of the trust. Okay, question, but it depends on what the actual grandfathering said. If it specifically called out that situation and said, if this occurs, then grandfathering ends. I doubt it does. Then it is possible that the grandfathering could end, but I'm like 99% sure that the grandfathering will continue. Okay, question 16. We are currently in the process of amending our 1995 bylaws. We recently communicated with our property manager that we wanted our amended version and red line version emailed to our community, along with an explanation letter stating that they would receive a ballot in 30 days to vote. Instead of emailing the materials, they were snail mailed. This mailing cost us $1,500 due to the number of pages back to back, color, large envelope, and postage. Our manager refuses to take responsibility for this. We have repeatedly emailed her and the company VP, but we are getting no response. What, if any, repercussions do we have to resolve this issue? We don't feel like we should have to pay this exorbitant mailing. Okay, this is a good example of miscommunication between a management company and the board. I'm assuming when you say we communicated with the manager, we wanted this emailed to our community that was in writing and you can show proof that that was what was discussed. And it sounds like maybe the manager made a mistake. You are not required to mail this by snail mail under state law or your documents. You're just informing the owners that this is what we're proposing and a ballot's going to be coming in 30 days. It sounds just like a miscommunication. So what I would recommend that you do is you reach out to higher up in the company. If the manager is not responding to you, maybe even the president of the company, if the VP is not responding. And, what they really need to do is they genuinely do need to reverse that charge, and it'll tell you a lot about your management company. Are they customer service oriented? Are they accountable for mistakes? If they reverse the charge, yes, then that'll show you their true colors. If they refuse to do that, then obviously that's going to leave a bad taste in your mouth. And you may want to think about making a change in your management company. So hopefully the management company will do the right thing on this. Okay, question number 17 is from a board member and treasurer. For a small self-managed condominium association, what is the best practice for HOA boards when approving routine or time-sensitive maintenance expenses? Is the board required to hold a formal meeting and vote on every individual expenditure, such as a cleanup, replacing dead landscaping, or urgent repairs? Or may the board delegate authority or approve spending within an adopted budget without a separate vote each time? Oh, this is a great question. I like it. I personally, in my practice as an attorney representing associations, I like it when I see boards having guidelines and guardrails for things like this. So yes, I do feel that the board can delegate or approve spending within an adopted budget or within a certain dollar amount. If you want to allow your manager or a board member to take action on something, and it's an urgent repair or emergency, or maybe we tell the management company you can pay the electric bill and the water bill every month without having us vote on it individually. So I'm fine with that. Just make sure the minutes reflect what the guardrails are or the approved spending limits are and how emergencies are handled, et cetera. And that's fine. I'm okay with that. The only exception to that would be is if your documents have some sort of a limitation, like the board can't spend more than $5,000 without having a meeting or without a vote of the membership or something like that, then we would have to still comply with whatever your written documents, your CC&Rs, bylaws, or articles would require in that situation. Okay, question number 18. Our HOA will not share copies, and this is from an owner. Our HOA will not share copies of architectural change requests and subsequent board approval or denial letters if a records request is made. They claim it is considered personal information and they don't need to disclose it. How would you interpret the ADRE standards? Disclose or not? So I actually think these should be disclosed. I don't think it falls under any of the categories. The only exception to this would be is there's pending litigation. It's possible that we would not disclose it under the pending litigation section of the records request section in the documents in the state law. We would be able to withhold it, but honestly, why would you? I think that if it's public record as part of a lawsuit, you're able to go find it by going down to county courthouse. So my feeling is share it. I think you should disclose if somebody or a neighbor wants to see architectural change requests and the board's subsequent approval or denial letters, I would provide it to the owner that's requesting it. You can charge 15 cents per page. if you are so inclined to do so, if they ask for an actual copy of it. Okay, next question. Number 19 is from an owner. If 2 board members and a 1 committee member, landscape committee, meet for a non-regularly scheduled meeting, does that gathering constitute a quorum of the board? I really don't know what your number of board members are. So if you have a 3-member board and 2 board members are meeting, then yes, that probably is a quorum. If it's a 5-member board, which I know your association, I think it is a 5-member board, 2 board members is not a quorum. Now, I don't know about the committee member. It's landscape committee. I don't know if they're on the board too, or you just recognize them as a committee member. So I'm going to consider them not being on the board. But it really, the answer to this question is how many board members do you have total? So if you have 5, 2 is less than a quorum. If you have 3, 2 is a quorum. The committee member really doesn't count towards the quorum of the board unless they're on the board. Okay, next question, number 20 from an owner. Our CC&Rs prohibit more than 3 unrelated individuals from occupying a home that is rented. How do you recommend this be enforced when a home clearly has more people living there? Okay, this is kind of a sticky situation because first there's situations where we have multiple generations of families living in a home, like grandparents, parents, children's children, and under county and city and municipality ordinances, that is considered a single family, even though it's multi-generational. In your situation, you're saying, okay, our CC&R say no more than 3 unrelated individuals can occupy a home that is rented. And so how do we check this? Well, a good way to do that is under state law. There is a law that if it's rented, we are entitled to get the names and of anybody that's living there as part of the rental. So you certainly can, as part of your request for information, you can ask for how long is the tenancy or how long is the lease. You can ask for the names of the adults that are living in the property. You can ask for the vehicle descriptions of the individuals living in the property. So, you can send a letter asking for that information. They have to provide it to you. Now, what typically happens in a situation like this, in my experience, is if they have 6 people living there and you think it's like maybe a roommate situation and they're not related to each other, they're probably only going to put 3 people down, right? So you're asking not the tenant, you're asking the owner, landlord for this information because they're the only ones that are contractually obligated to provide this to us. I guess if you think that they do have more than 3 related people or 3 unrelated people living in the property, you may want to turn it over to to the attorney for the association, have us write a letter saying, hey, we have reason to believe that there are more than 3 unrelated people. Here's the evidence that we have. There's 6 cars parked there. The 3 names you gave us, there's also seem to be 3 other people that live there too, and just try to hash it out with the owner. It's possible that the owner may not even know about it too, may not even know all the people that are living there. And so I would say open lines of communication by asking for the information first. And then if they provide it to you and you think it's not accurate, then maybe get your attorney involved. Okay, next question, number 21. ARS 33-1804 states that a meeting may be closed only if that closed portion of the meeting is limited to consideration of 1 or more of 5 topics. Most are easy to understand. However, we would like clarification on the definition of personal information in the 3rd section. Is the definition in ARS 18551 an appropriate guideline for us to use? If not, please give us a definition we can use to decide whether a specific discussion being contemplated qualifies for closed session or should take place in an open meeting. Okay, I'm just going to do a quick look at what 18551 is, so I can take a quick peek. Let's see, ARS. So my typical answer on this is going to be, okay, so just for background information, for those of you that may not have knowledge of the statute. So we're talking about the executive sessions statute, right? And so all meetings of the association must be open meetings. The board does have the right to go into executive session to discuss 5 topics. One of the topics that they can discuss in executive session is personal information. So My normal canned answer on this is what is personal information? So how you want clarification on the definition. I can't give it to you because the legislature in the Condominium Act and the Planned Communities Act didn't give us specific examples, but I can tell you how I've interpreted it. So like social security numbers, that's going to be personal information. Cell phone numbers, that's going to be personal information unless the owner has agreed to be like in a community directory and they gave us the cell phone number. Out of state addresses is going to be personal information. Information regarding a domestic abuse or domestic relations issue that may have occurred on the property. That's going to be personal information if we're discussing that. I've seen it in the capacity of maybe we have an owner or a guest or tenant who's living in the property who has dementia, and there's some problems that are occurring because the person may be roaming, or maybe they're behaving in a way that is not the way that, maybe they're violating rules or something like that. So those give you some examples of the types of personal information that we may talk about during an executive session. It also could be like a financial situation, like I can't pay this bill and I need a payment plan. That would fall under personal information. I'm just going to take a quick look at ARS 18551. Yeah, I don't think this applies because this is under a totally different section and it's not going to be similar to the context that we're looking at. So I hope that answers your question. Okay, question number 22. This is from a community manager. And the question is, what recourse do homeowners have if the board is not answering a concern? We have a unit owner who is having a gas fire each night under his covered roof on the back patio. This is dangerous and against our rules. The board has been made aware by 3 owners via email and has not responded. This is a potential for risk. How can owners who are not on the board handle grievances? What steps do they need to take above a board? So I don't know how you're contacting the board. Make sure you're doing it in writing so there's evidence that it's being handled. So what are your recourses? Go to a board meeting and express your concerns during the open session for sure. That would be one suggestion. Document your concerns in writing. That's a safety concern. If you know who the attorney is for the association, write the attorney a letter as a homeowner, or write your attorney the letter stating, hey, the board isn't taking action on this. Write the management company. It's interesting that this question is being written by a manager and the board's been made aware but won't respond. So as a manager, you may want to document your concerns in writing at a board meeting that, hey, we need to take action on this. This is dangerous. If the board continues to have inaction on this, what are the options for owners? Owners that are complaining about this can go to the ADRE, Arizona Department of Real Estate, and file a complaint against the association. They can hire an attorney to write a letter. The owners can file a lawsuit. That seems like kind of overkill based upon what this issue is. The owner also could write a letter to the owner that's having the gas fire and say, hey, this is dangerous and we're concerned about it. Please don't do this. And so I think that gives you some good suggestions on different actions that you can take. As the manager who's writing this question, document. You may even need to bring this to the attorney's attention. You may need to bring it to your supervisor's attention at your management company because this does seem like something that could escalate and be a hazard. Okay, next question, number 23. Is there any Arizona statute that mandates the position of board secretary be filled? I don't think so. But your documents, typically in your bylaws, it does say that the secretary position, that there is a secretary position. You could maybe, if your bylaws allow you to, you could load up on positions like secretary treasurer or vice president secretary. And really, board secretary should be a relatively easy position. Really, all you're doing is taking the minutes. And oftentimes, if there's a management company, they're doing that for you. Okay, next question, number 24. From a board member, if annual board meetings are recorded, is it still necessary to prepare written meeting minutes of the annual meeting? So short answer, yes. You always have to have in writing minutes for regular board meetings and annual meetings, even though it is recorded. Question number 25 from a board. Is there anything an association can do regarding vehicles that have mufflers on their cars that backfire and create an offensive noise in the community? So great question. There's a nuisance provision in every set of CC&Rs. And what I would recommend is that the board write those owners a letter talking about the noise, creating a nuisance, and treat it like any other violation in the community. It would be great if we can actually have like a video or an audio recording of the nuisance so that we can play that for the owners so they can hear it. They don't believe us. But I would say violation letters, fines, escalated to the attorney if they continue to not have that fixed. Okay, next question, number 26. Our flat and shingle roofs are 100% maintained by the HOA per our documents and are under a warranty by a roofing company for their recoating. When there is a leak that damages the inside of a home, the residents have been told to use their own insurance to do the inside repairs. Whose responsibility is the interior damage? HOA, roofing, contractor, or resident? I mean, it really depends on what was the cause of the damage, but I'm assuming a leak is going to be a maintenance thing and it's not going to be caused by somebody removing a satellite dish from their roof where they caused the damage. So let's just assume that this is just normal wear and tear and there's a leak. The association maintains it, right? And even though they may have a warranty by the roofing company, leaks happen. And so what the association's responsibility is to get the roofing company out there under the warranty to fix it promptly. And the responsibility of the owner is to notify the association immediately and to do everything possible to mitigate any damage from the leak. But ultimately, if the root cause of the leak is due to the fact that it wasn't being maintained or that it just is a wear and tear leak, the association, in my opinion, is responsible for the interior damage. Now, if your CC&Rs say that these type of damages need to be made on the owner's insurance, then you may have to make it on your owner's insurance. I really don't see that provision very often. More likely than not, it's going to be the association's responsibility to fix this. The roofing contractor, the recoating warranty is just that. They have to come out there and fix it. So I don't think they're going to have any liability here. Okay, next question, number 27 from a board. What are the local utilities' responsibilities for maintaining the aesthetics of their infrastructure and for removal of above ground components when they are no longer in use? Can an HOA compel the utility to perform such maintenance services? So yes, we've had this issue before many times where maybe there's wires that are dangerous hanging out of the utilities' ground components, or maybe they've been damaged from a car accident, or maybe they're just looking really horrible, or maybe they're just not in use anymore. So yes, I would send a letter and the squeaky wheel gets things done. So I would say continue to follow up with them. And they do have a responsibility to maintain the infrastructure and to remove it if it's no longer being used. Question number 28 from a board. We had to condense this one because it was a little bit long. Our association elects board members by paper ballot, requiring approval from 51% of all lot owners for a candidate to be elected. Ballots are due by February 13th with the annual meeting scheduled for February 14th, which requires a 30% quorum of lot owners to conduct business. If the annual meeting does not reach the 30% quorum, but the election achieves the 51% approval threshold, can the election results still be validated, or must the annual meeting be rescheduled to obtain a quorum? Okay, good question. Sounds like a lot of annual meetings coming up in January, February, March, and April in Arizona. So it looks like we need approval of 51% of the owners for a candidate to be elected. I think they call that like the plurality of the vote. And there's a quorum of 30%. So I guess that the question is, I'm not sure that you guys are fully understanding. So if you have 51 approval threshold, you're probably going to have the 30% quorum. So what you're saying is that the annual meeting doesn't reach the 30% quorum, but the election achieves 51% approval. Can the election results still be validated? So your ballot for the election should also count towards the quorum. So yes, it should be fine. Now, if you're electing the board by paper ballot, I'm assuming that you're using like a action by written consent, and that, depending on how it's worded, it should also apply towards the quorum. So maybe you might want to show me the ballot that you are sending out. just to make sure that are wording it properly. But if you're going to achieve the 51% threshold, maybe when we condensed it, we flipped it. So let's say that you get the quorum, but you don't have the 51% approval threshold. Well, then, yes, you will still have to continue to work it until you get that. And that may require you to, reschedule the meeting or continue voting to get the requisite vote to elect the directors. Okay, question number 29 from a board. If a board has revised a document like the design guidelines that contains rules that violate state statutes and the community declarations, and has been advised of the issues and asked to correct them or come up with a plan to correct them and not responded in months, what can the members do? Elections are too far out for putting up a slate of candidates to run against the current board, and trying to remove board members through a petition and vote is risky. Okay, so it sounds like this is actually from the board. And so your board, the question is from a board member, which is kind of interesting. So you're saying your board revised your design guidelines, and some of the things that they put in there don't jive with state law and with your association's documents and violate those particular things. And the board's been advised, hey, correct them or come up with a plan to correct them. And they haven't done it. So what do we do? Well, I think the most important thing is document in writing, number one, that this is occurring and ask the board to correct it. If they won't correct it, and you can do that by sending letters, attending a meeting and expressing your concerns, asking your comments to be placed in the minutes. If the board doesn't take that action and you don't want to remove them from office, and maybe elections, like you said, are so far away that it's not realistic. Maybe you've got 10 months before the next election or something. What you could do is go to the ADRE and file a complaint against the board for the violations that they are allowing by having the design guidelines violate state law and violate your association's documents. There is a $500 filing fee to do that. You could also hire an attorney. Collectively, you could get people to hire an attorney to notify the board that, hey, this is a violation, needs to be corrected. You could file a lawsuit. You can run for the board. You can remove the board. These are all different options that you have. Okay, next question, number 30, is from a board member. Just to give you a little question check, we have 36 questions total today now. Okay, what are some initial steps that an HOA should or can take in the event of a death of a homeowner on a unit that has a sole owner? We have a homeowner that recently passed away. Family members have reached out about the unit. However, we have no documentation of an authorized rep. We are not sure who we are allowed to share information with. Okay, so great question. So we do see this frequently where an owner passes away. One of the things that you really want to look to is oftentimes we don't have next of kin information, and they typically will contact us if we're sending letters to the estate of the homeowner at the property address. The family will then get that and then they'll reach out to us. I mean, I'm fine with sharing information with them, even though it probably does violate the Fair Debt Collection Practices Act, because we're only supposed to communicate with the debt about the debt with the debtor. But let's be real here, the debtor is deceased. A very low likelihood that we're going to get sued on that Fair Debt Collection Practices Act for talking with the next of kin. Where it gets sticky is if the next of kin don't get along, or somebody thinks that the property is theirs and the other person doesn't agree, and that just gets kind of a nightmare. Well, what you want to do is it's okay to provide information regarding how much is owed on the property. You can ask them what their intentions are. If they don't pay after a few months, I would recommend leaning the property and doing an analysis as to, was there some sort of a reverse mortgage, or is this paid off, or how much is the deed of trust or mortgage on the property, and really think about what the debt to credit ratio is, because that may, if the next of kin doesn't pay the assessments, then what are our next legal steps? Is it a good idea to foreclose? Is to get the property, get somebody to buy it? Usually they sell it and we get paid at the close of escrow. But these are all some initial steps. I would say once the assessment is 3 months behind, I would lean it, send it to the attorney, and do a credit analysis of the deceased and the property itself to see how much it's worth versus how much is owed on it to determine what the next step should be. Okay, question number 31. My association engaged another entity to put up Christmas lights at a corner in the community. In the financial statements the following month, I caught an entry for $1,050 made out to an individual, and the amount echoed to me as it was a deposit for the Christmas lights. I then checked in the Corporation Commission database and found that the business name is not a legal entity, but a trade name. Endorsing a check to an individual for this kind of thing smells a lot like someone not reporting business income. Is there validity to my concern? I mean, it's hard for me to comment on this without hearing more from the association. And it looks like on the financial statement, it just had an amount to an individual, but there's no evidence that this was related to the Christmas lights. So I guess here's my advice for associations. Really, you should always be hiring licensed, bonded, and insured contractors. So if your association is just hiring like a random person to put up Christmas lights and they fall while they're doing it, it's a liability for the association. So I don't know specifically what the circumstances were here because I don't have the other side of the equation here, the board telling me what happened. But my concern here is not necessarily that this person may not have been reporting business income. My concern is the liability for the association. Okay, and the bottom line is you should always be hiring as an association licensed, bonded, and insured contractors to handle things at your association. Okay, question number 32. The current board is publishing minutes via the cloud, which requires download the cloud site, which is a purchase. Can we request it in Word or a free site? Of course, you can request it. It will be 15 cents per page. Okay, question number 33. I'm an owner. Is there a statute that states fees cannot be applied for a violation until the appeal has been addressed and the homeowner is heard? Does HOA have to send a letter that the appeal was denied? If the HOA cannot state what bylaws I am violating to deny my appeal. Okay, so a couple things. So you're an owner. You're wondering, probably sounds like maybe you have a violation and maybe there were some fines that were levied against you. So here's the law in Arizona on fines. An association has to give notice and an opportunity to be heard before levying the fine and putting the fine on your account. So there is a state statute that says that. You can go to our top 10 cheat sheet on our website at mulcahylawfirm.com, and we talk about fines and the proper procedure for fines. So yes, there is a statute that addresses fines. We have to give notice and an opportunity to be heard as an association before we levy the fine against an owner. Let's see, does the HOA have to send a letter that the appeal was denied? So if there's an appeal, like the notice to be heard, notice opportunity to be heard, and the board has an appeal or they have you appeal it in writing, really in the letter where they make the decision, they do have to send a letter out saying we are fining you or we are not fining you or the appeal is denied or whatever. Yes, that does need to be in writing and you need to be notified of it. If the HOA cannot state which bylaw I am violating, does that mean I'm automatically denied? Not necessarily. It depends on what exactly you did. I mean, it might be a nuisance thing, which is a little more nebulous. It might be something in the CC&Rs. So I'd have to look at that on a case-by-case basis to weigh in on that. Okay, next question, number 34, from a board member. Is it okay to have an open working session between all board members, committee chairs, and committee members? And even though residents of the community are invited to attend, they are requested not to speak as it is a working session only among board members and committee members. So great question from a board member. Yes, that is okay. The only time owners are specifically allowed to speak under Arizona law is before the board takes formal action on something. So if there's going to be a vote at that open working session, then owners would be allowed to speak. Otherwise, if it's just a working session where there's no voting being conducted by the board, then it's you're well within your rights to say no comments from owners during this open working session. Okay, question number 35 from an owner. Does a $100,000 salary for a manager of a 742 resident community seem excessive? I would say no, it does not. You might want to look at CAI, the Community Associations Institute, has conducted a salary survey of managers throughout the US, and they break it down and give you by region, by how many lots or units in an association, high rises, condos, planned communities. they give you a breakdown of what the different salary ranges are. So I have the ones from, I'm not sure if I have the updated one, but I for sure have the one from 2 years ago. They update it about every 2 years. And this is well within the range pursuant to that salary survey. And in my experience of working with over 2,000 associations, that does seem, 100K does seem like about the approximate salary for a property that large. Okay, last question for today. Should the board vote to close the public meeting before going into an executive session? 33 Arizona Revised Statutes 33-1804 says any portion of a meeting may be closed. So typically what happens is most boards have their open board meeting first. And at the end of the board meeting, they say, I'd like to make a motion to adjourn the open meeting. And so that's how we vote to close the public meeting. Remember, if your board is going into executive session, the notice of the meeting for the open board meeting should also state that there's going to be an executive session. So that's going to be the notice for the executive session, which you are required to give 48 hours in advance as well. And then what sections under the statute, the executive session statute, you're going to be discussing during executive session. So very important that your notice of executive session includes that, and also includes an agenda that doesn't have a lot of detail, but that does talk about what you're going to be discussing. Okay, so we had 36 questions today, which was amazing for our January 1st Fridays. We had 72 viewers at peak today, which is also great. Thank you so much, everybody, for joining us here. We had 12 on Facebook as well, which is amazing. We have some information about some classes that are coming up here in January. So we have our next 2026 virtual HOA Condo Academy class number 1. And that is coming up on Tuesday, January 20th at 2026. So we hope you will join us for that. And that starts at 11 o'clock. And it will be on Zoom and Facebook Live. If you want more information on that upcoming class, you can go to our website at mulcahylawfirm.com. We also are going to be conducting an in-person class, which is our only in-person class in January. And that's going to be with the Scottsdale Neighborhood College on Thursday, January 29th, 2026. I will be teaching that one myself. And that will be from 1 to 3 o'clock p.m. at the Mustang Library. You can go to our website to find out more information on what topics we're going to be talking about at both of these classes. And then, of course, we've got our February 1st Friday. So we'll go back to the first Friday of the month in February, and that will be Friday, February 6th. And I'll be hopping on Facebook Live and Zoom to answer your questions, probably between 9 and about 10:30 in the morning, depending on how many questions we get. So thank you again, everybody, for being here today. We appreciate you caring about your associations and wanting to learn more about our industry. Have a great month of January. Hope to see you at one of our upcoming teaching classes in January. And I wish all of you a happy and productive new year in your associations. Hope to see you soon. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.